I'm sorry for being late. Mr. July, before I remind the witness that is still under oath, are you ready for you to put some questions to Mr. Mr. Cole, I have to remind you that you are still under oath.
Thank you, sir.
Yes. Mr. July will...
Sorry, Mr. Chair. Mr. Cole has asked me to just seek your permission where he wants to make certain concluding remarks. He says he was exhausted at the end yesterday and he didn't get to finish all of his concluding remarks.
No, it's okay.
Thank you very much, sir.
Yes, yes, Mr. Cole.
Mr. Ombudsman, I concluded yesterday where I said that I worked tirelessly for 20 months on this investigation, and that in all my dealings with all the witnesses, with the CEO, with the board, with Judge Mngwepe, and then especially Mr. Becker, who I experienced as a person of integrity and professionalism, I've tried to be as professional as I can. In these circumstances, I'm really disappointed that our integrity has been attacked, not necessarily here, but in the media and elsewhere. With all the negativity around CSA during the past few months, I think I just need to mention that at the conclusion of the sanctions by CSA, the CEO of ICC, Mr. Dave Richardson, made a media report where he congratulated CSA on its professional and thorough investigation. Similarly, when Mr. Bodie was convicted in the court, the NPA made an independent media release where they also congratulated CSA on the report. The FICO, which is the Federation for International Players Association, the mother body of SACA, congratulated South Africa and SACA for its model in trying to educate players. This, in my opinion, is a good news story for CSA as opposed to all the negative reports that had been given in the media. What is even more disappointing, and I did allude to that yesterday, was that this process is really important for cricket in South Africa, for us to normalize. And the picture that had been painted just doesn't match up with this. It is really sad that that has happened. There can be no doubt that the reputations and the careers and of the players and also that of their families have been adversely affected by this whole investigation. And I'm really sorry for that. I don't want to see anybody go to jail. It is just the fact that it is a separate process, and it is unfortunately telling that these players have not accepted responsibility for their actions. And it is a pity that they've portrayed themselves as victims of racism and unfair discrimination by CSA in this investigation. I think they failed to appreciate the harm that they've done to cricket in South Africa. The public are now very skeptical about South Africa's, the CSA's processes to eradicate corrupt activities. Even more telling is that companies who want to sponsor cricket now don't have confidence in the processes that we have. I need to add that Ram Couriers, who were the title sponsor for the Ram Slam competition, withdrew after the investigation. Cricket South Africa is dependent to a large extent, except for the broadcast monies, to collect revenue, to pay the players, and to ensure that cricket is played on a level field. What is more damaging is that the harm that these players have done to the anti-corruption drive, which Cricket South Africa takes very seriously. The players in my recent education sessions with him, as well as with the previous one after the Robert Marawa revelations by these players, the players have started questioning me about my integrity. I think that the harm that it does, it prevents players in future coming forward to the person that they should trust to enforce these regulations and also to try and keep the game clean. In this regard, despite all the allegations, I have to acknowledge the role that Mr. Craig Alexander and Mr. Vaughan van Jaarsveld have played in bringing forward or these allegations and fulfilling their obligations to report timeously to Cricket South Africa. I know that them and their families have also suffered greatly. I once again deny that any of these, or that the investigation in any way targeted back players. The players were charged based on the evidence that we collected. As I alluded to the fact that we simply followed the evidence. The one led to the next. Mr. Bodie in the video clearly states that he identified these players and it is backed up with all the WhatsApp messages in terms of his whole process. He told us, and Mr. Peterson told us, who it was that was involved. We simply followed the evidence. Presumably, the suggestion that I targeted, that I treated black players and different to the white players, is based on the fact that Mr. van Jaarsveld, I did not charge Mr. van Jaarsveld for that. We also did not charge Mr. Peterson for that. We also did not charge Mr. Craig Alexander. The elephant in the room really is Mr. Alexander. He reported 2 months late. He happens to be a colored player. Each of these players knew exactly that Mr. Alexander was also a whistleblower and that he reported late. Yet they tend to focus on Mr. van Jaarsveld, who was 2 days late. If Mr. van Jaarsveld had been charged, and not Mr. Alexander had been charged, and not Mr. van Jaarsveld, then there could be an argument that we treated players fairly. That is simply not what we did. I want to refer the Ombudsman to paragraph 223 of my affidavit, where we deal with this specifically. And the fact that I'm not able to present my argument fully, I was told yesterday that I have to keep it short. I need to refer to this because it deals specifically with this. And I'm going to read that so I don't overlook things. Mr. Peterson suggests that he was charged for reporting late because he reported it to Tony Irish on the 8th, but did not report it to me on that particular day. This is not why he was charged. The charge that he cross-referenced during his hearings, and I say charge 3 of his notice of charge, reads as follows. You failed to disclose an approach made by Mr. Tsolakili on 5 October to the designated anti-corruption without unnecessary delay. And I'm going to interrupt myself quickly by just referring to the anti-corruption code in this regard. Article 2.4.5 says, failing or refusing to disclose to the designated anti-corruption officer without unnecessary delay full details of any incident, fact, matter that comes to their attention. And I'm going to skip that, would amount to a breach in this. And the note below that is telling. It says all participants shall have a continuing obligation to report any new incident, fact or matter that may evidence an offence in terms of under the code. Even if the participant's prior knowledge has already been reported. And then the last section, it says, it is acknowledged that the assessment of whether there had been unnecessary delay in each case will depend on its own circumstances. This is what we as a panel considered, each of the late reports on its own merits. For a participant to wait until after the match, and I will then say, or soon before the match starts, of which he is invited to engage in corrupt conduct before reporting that approach. That is why there's a difference in the way that we dealt with these players. I'm going to go back to my concluding remarks. paragraph 2 to 5, it says, it is clear that this charge has nothing to do with the period between the 8th that he reported it to Mr. Irish and the 12th that he reported it to me. This charge related to the fact that he did not give me adequate information. He selectively told me what he wanted me to hear, and he omitted material information about his meetings with Mr. Bodie. Full details of the 5 October meetings were only disclosed for the first time by Mr. Peterson on the 18th of January, which is more than 3 months after the report should have been made to me. In any event, this charge was waived as part of a sanction agreement. I will then let me just go. I'm finished with that section. I'm going back to my concluding remarks. I'm going to go further that what has happened with these allegations, sir, is that they've made the anti-corruption drive very difficult. And after the numerous appearances on national television and also on the Robert Marawa show, the players have really become skeptical about my role and my objectivity. Players have actually approached me to say, in a respectful manner, that what is this that you have been involved in? Much of the groundwork that had been laid by the anti-corruption unit and also SACA in educating the players have unfairly been placed into question. Without the confidence of these anti-corruption processes, the players will just not come forward and report to me. There's a clear difference between the facts relating to Mr. van Jaarsveld and the facts relating to those the other players that had been charged by Cricket South Africa. I also deny that Mr. Becker and I intimidated or coerced or threatened the implicated players. A criminal charge was laid fairly early on in the investigation, and there was no factual basis for them to claim that I threatened with something that I had already reported. Mr. David Woodhouse yesterday also confirmed the fact that the dealings with each other was cordial and professional. The reality of the situation is that these players just don't have clean hands. They conducted themselves and they committed corrupt acts in terms of the anti-corruption code, as I alluded to yesterday. The information that had been made available to me was made available to the police. And I did lay a charge early on, and it's up to the NPA to decide whether they're going to charge them or not. Besides Mr. Symes, Mr. van Jaarsveld was the only other white player that was identified during the investigation as having been approached or being involved. There's a clear indication that Mr. van Jaarsveld said no, Mr. Alexander said no, and Mr. Peterson engaged with these bookmakers on various occasions. I don't want to burden the Honourable Ombud with...
I seem to have heard everything that you have said yesterday. I can quite understand that you are very emotive about all of this. Everybody is who believes that he has been hard done by. But it will not add anything, more than what you have already said.
I understand that, sir, if I'm then being questioned on my motives about why we charged or didn't charge, it becomes relevant for me, and it's important that the Ombud then understands that there is evidence based on that.
As I say, you may not be aware of it. What I've heard today, up to this point, is a rehash in other words and in other forms of what you said yesterday.
It's my conclusion, sir.
Yes, you did deal with your conclusion.
Thank you very much.
Yes.
I have nothing further to say, sir.
Yes. But, I felt I needed to give you an opportunity because at least you impressed me as somebody who feels strongly about these things. But so also did the players who came before me. And as I said to you yesterday, it is going to be my very, very, very heavy task to deal with all the evidence, which is why everybody has been given an opportunity. And Mr. July?
Mr. Cole, can I put you at ease? Yesterday you indicated that we accepted the evidence of the players. No evidence has been accepted. We have listened to everybody who is here as to which evidence we have accepted and not accepted will be contained in the report. So for now, when we listen to you, nobody should say we are accepting your evidence. When we listen to the players, nobody should make allegations that we are accepting. We're not accepting anybody's evidence or rejecting anybody's evidence. So be at ease on that. Yes. The other issue is that the questions that I'm going to ask you are for clarity. All what I want is just clarity. Now that we have testified about your role in the investigation, I just want clarity. Before I ask you those questions, you indicated that you started in January 2015. Is that right? Before that, where were you employed?
I was retired for a couple of years.
You were a retiree. You retired?
Yes, sir.
As what?
As a policeman.
Okay.
As a?
Policeman.
Policeman?
Yes, sir.
Yes.
Now, you retired as a policeman, and then the position became available at CSA, which is the position of the, what do they call it?
Designated anti-corruption officer.
Designated, yes. And that position existed. Was there a unit which is called corruption unit at CSA?
I think I testified yesterday that there was no such, that the ICC in the recommendation said that every domestic board has to have an anti-corruption. So there was no anti-corruption unit.
Mr. Cole, I don't want to be unfair to you. I want you to feel very free in answering your questions. And I mean, one of the things that anyone who sits and presides over any hearing is what one calls demeanor.
Sorry?
Demeanor.
Demeanor.
Yes. Your lawyer will tell you that is what sometimes one looks at. And I just want you to accept right from the beginning that, as Mr. Julai said, no one is sitting in judgment already of the nature of the evidence that you are giving. I also do not want to feel uncomfortable and get the sense that your demeanor is different when you answer questions from Mr. July. It's different from when you answered questions when you were being led by your lawyer. Once again, relax. Nobody's at war with anyone. Not in the least the people who assist me. Certainly, I'm not in a position to be at war with anyone. But I don't want to feel uncomfortable that you have a different demeanor when questions to clarify certain aspects of your evidence. As Mr. July said, he is intending to just relax.
Thank you.
Mr. July?
Yes. You testified yesterday that there were 23 players
Yes, sir.
that you investigated. And you testified that, and it's also contained in your affidavit at paragraph 21 of your affidavit. We don't have to go there. And of this 23, then you've got the 6 or 7
That had been.
that have been found too. Can you explain to me how you went into town explaining how you interviewed the ones that were found guilty? In you not finding or coming to the conclusion that these 23 were not guilty, how did you go about it?
Basically, Mr. Lombard, as each of the players was mentioned by either Mr. Peterson, Mr. Bodie, or Mr. Tolekile, I dealt with each one. So if it was a national player by the name of X, I would then look at the evidence. I would then interview Mr. Bodie about what was the involvement. I would go through the WhatsApps. I would go through Mr. Bodie's telephone records to see if there was any interaction. The police had assisted me with what we call spider webs, which connected the various telephone conversations with between Mr. Bodie and certain players. And those names inevitably never came up. Or if they came up, it didn't match up with the evidence that we had that they'd ever been approached in that regard. Names were also just thrown up by Mr. Bodie specifically when he recruited these players to say, if X was involved, you don't have to worry about that. They are also involved. So it was a definite mechanism that or method that he used to put the players that he was approaching. Mr. van Jaarsveld says that in his affidavit, and he also says that Mr. Alexander as well in his report that he gave to me with regard to the approach, the one that came via SACA, that was the method that Mr. Bodie used.
Will you be in a position to provide us with a report?
Yes, absolutely. It's just not for public consumption, because I think it would be unfair to these players who are totally innocent to give you to mention the names in the public.
No, I agree with you.
Yeah, I'll make that available.
But we can't mention those names.
Yeah.
But I think this forum deserves to
Absolutely.
get that report.
Mr. Chair, with all due respect, there hasn't been a suggestion by any of the players that they have been discriminated against because the other 23 were not charged. The allegation has been that they have been discriminated against because Vaughan van Jaarsveld was not charged. So I don't understand why a request is being made for the report relating to the other 23. We were careful enough yesterday to talk about making sure that this inquiry does not get stuck into an inquiry about the match fixing allegations, and only to deal with the question of discrimination and unfair discrimination that may have arisen in the match fixing investigation. My understanding is that none of the players that gave evidence before this inquiry suggested that they felt discriminated against because the other 23 were not charged.
The other 23 being white players?
No. So my understanding is of that 23, there were 75% that were black and 25% that were white. But Mr. Cole can correct me if I'm incorrect in my memory.
Mr. Musaji, Just to correct that, on paragraph 59 of Balati's affidavit, he says, I also think that those of us who were charged with match fixing were unfairly targeted and discriminated against. There were other players whose names were mentioned with regard to match fixing allegations, but they were never investigated, charged, and sanctioned like us. Hence, Mr. July's then request for the report.
I still don't understand the relevance, because there isn't the suggestion that that deals with the 23 players. It's a different thing if Mr. Mbalati was questioned in these proceedings to say, you are identifying other players that should have been charged that were not charged, so that Mr. Cole could then deal with the specifics. If he was told Mr. X was not charged, but I was charged and therefore I was unfairly targeted, then Mr. Cole could deal with that comprehensively as he had done in his submissions. That was never put to Mr. Mbalati.
Mr. Chair. Mr. Cole testifies and said those 23 players were investigated and they came to the conclusion, him, Mr. Becker, and Judge Mwebe, to the conclusion that these players were not guilty. All what I'm asking is, can you then, in your report, show us how did you come to that conclusion? As you correctly pointed out, this forum is not about whether match fixing. We are not going to change the finding, but we need the whole picture. That's all what we're asking for. And that testimony has been given here, that the conclusion was reached. And I think it's only fair that you know how that conclusion was reached.
Is the report available?
Just repeat that, sir.
Is the report that you compiled available?
Not specifically in terms of how I went into each of these players, but I know the process that I followed. And there might be references to it in some of my correspondence and my reports and discussions that we had, but I'll make the list available. I have no problems with that.
Okay. Yes, I would assume, Mr. Cole, that when you conduct an investigation, then there's a report. I'm not asking for a list of the employees.
I have a report that I did not release because the criminal case had not been concluded yet. But in that, I deal with a lot of these players. I think there are notes that I have that I deal with each of these. It is a lot of documentation.
Is there a written report about your investigation?
Yes, there is.
Yeah. No, I think I would like to look at that.
It's no problem.
Yeah.
Now, Mr. Cole, the 25%, the 75% of that 23, as I understand, it's your black players. The 75. The 25 is white players, and so far we only mentioned 2 white players, and which is Mr. Sims and Van Niersveld.
Yes, sir.
Am I therefore correct to say there are other white players? I'm not saying mention their names, and I agree with you, but I just want to confirm that there could be other white players other than the 2 that have been mentioned.
Yes.
Okay. As I understand the evidence of these players, they make also...
Which players, sir?
The players who came here. The players who came here and testified.
Yes.
They make all sorts of allegations.
Correct.
About you and Mr. Becker and that. But what they don't seem to be denying is their involvement in one way or another in the match fixing. At whatever level, there's something they were approached. This is what they did. But they seem to be complaining about the manner in which the whole investigation was conducted.
Mr. Chairman, sorry to interrupt again. In my view, that's a misrepresentation of the evidence of some of the players. A lot of the players that gave evidence did not concede that they were guilty of the charges, and in fact suggested that the only reason they agreed to conclude the sanction agreements was because they were intimidated, coerced, and threatened. So I think the question that is being put to the witness is an inaccurate statement of the facts relating to the evidence that was given before you.
I have no recollection of any of the players who came and testified here who said, I was not involved. I was not involved. As I understand their evidence, it's about the sanction that was given to them. And of course they vary in how they present. They didn't come here as having one approach. They vary in how they present their situation. There are those who feel that they would not have agreed to the 10 years, they would not have agreed to the 12 years, 8 years, because it was too much. But I haven't heard any of the players saying I was not involved at all. If there is such evidence, then Mr. Musaji is at liberty to produce that.
By omitting to say what the involvement was and admitting something is two, in my opinion, two very different things.
Yeah.
Mr. Peterson, for example, only says that he declined to report. He all along denies his actual involvement. So he omits to present to the Ombud what he'd been involved in. And that is an offence can be an omission and a commission.
Yeah. As I understand, if we were to go to Mr. Peterson, as I understand, Mr. Peterson seemed to suggest that, for instance, on the 5th of October, he met with Tsolekile.
Correct.
Right? On the 7th of October, there's an exchange.
Yes.
There's an email, SMS or WhatsApp.
Between him and Tsolekile.
Yes, sent to his phone. And on the 8th, he then meets with Tony Irish. Then after the 8th, the next meeting was on the 10th.
Correct.
With Mr. Bodie. And on the 12th, it was a meeting with you and and that is the meeting where you say you were not happy simply because he did not tell you that Mr. Bodie was a middleman.
Amongst other things.
Amongst other things, yes, I accept that. But in your affidavit, you are specific in a particular paragraph that he did not say in that meeting that Mr. Bodie was a middleman. Right. I know that there are other things that he did not tell you. And also you have a problem with the details of the meeting of the 5th.
Correct.
He did not tell you what exactly was discussed in the meeting. Mr. Peterson sees himself as a person who was a whistleblower.
Sorry? He sees himself as?
As a person who whistleblew.
Yes.
And who came and tell you that there is this issue. And he heard from Tsolekile.
May I differ from you, Mr. July? A whistleblower.
You have to differ with me. Differ with Mr.
Yes, but if you want to purport yourself or portray yourself as a whistleblower by definition means that you have information, all of the information,
yes,
that you want to give to the person who's going to deal with that. If you selectively decide that you don't want to show your involvement with the bookmakers, you cannot portray yourself as a whistleblower. Therefore, there's a distinct difference between the genuine whistleblowers and Mr. Peterson, who was not a genuine whistleblower. That's why I differ with that definition.
Yes.
Sir.
As I understand your evidence, is that, and also contained in your affidavit, is that on the 11th of September,
Yes,
you were in Dubai.
correct.
And what you were doing in Dubai, you attended a workshop.
You can call it that. It's our annual conference.
Yes. Was it not a Keep Cricket Clean
Correct, yes.
workshop?
Amongst other things, yes.
Yes. So you can get to be told by the ICC about the involvement of Bodhi and in somewhere the Sri Lanka
Yes.
situation. And that, did they tell you about the possibility of him being involved in the coming November competition?
Yes.
Okay. What did they say to you?
The information note was very brief, and I think Mr. Becker, no, you won't refer to that. That, remember, it's information. There's a difference between information and intelligence. Intelligence means that it's been corroborated by a secondary evidence. The information that they got from Warnawira, who was the person that the ICC was investigating, that Warnawira and Mr. Manish Jain, who was the bookmaker that came to South Africa, that they tried to manipulate a game in Sri Lanka. And that in that investigation, the ICC then interrogated Mr. Jain. He said that Mr. Bodhi had been there in 2014 to discuss possible fixes in the Ram Slam. That information wasn't entirely correct, because remember, it's just information. He wasn't there in 2014. He went there between the 8th and the 18th of August of 2015 only. That was the vague. And the information was that Mr. Bodhi had spoken to him. Manish Jain says that he was offered $750 to give him weather information, and that they were planning to do something in the Ram Slam competition. That was the extent of the information that we had.
So what did you do with that information, that Mr. Bodhi is going to be involved in the fixing of the Ram Slam competition?
Well, that was on the 11th of September, yes. The very next day, unbeknownst to me, Mr. Vaughan van Jaarsveld and Mr. Craig Alexander was approached by Mr. Bodhi at Potchefstroom during the Africa Cup competition. I came from the airport from Dubai into a car and went to Potchefstroom. And my immediate impression was that I had to look for Mr. Bodhi. I then arranged with there was nothing that I could find, because I was unaware at that stage of the approaches to Mr. Van Jaarsveld and Mr. Alexander. So I then contacted Mr. Martin Vertegen, the intelligence person at the ICC who gave me the note, and asked him if he could come down to South Africa and assist me in the rest of the Africa Cup, because I had this thing in the back of my mind that there was a possible fix. At that stage, I couldn't really verify that. So I was busy with a tournament at that stage. It was not that I was at home waiting for something to happen. I had to go from match to match to match. My next match was in Bloemfontein a few days later. Then after that, the finals, I think, were in Benoni. So I had normal work to do, and I was trying to verify things as it came, and then the information came as it went. I then went to go and see the police, and I think that was about the 26th, 27th of September. I had discussions with him and with Mr. Gerinel, who was from the NPA. So I continued with my investigations as per normal.
You are moving very fast. I'm still on the 11th
Yes.
of September. You get this information on the 11th of September. My question, what then do you do with the information? I know now, I accept that it is not intelligence. What do you do with the information? Now you know that in November, which is in 2 months' time,
Yes.
this Bodhi guy is going to interfere with the competition.
In the meantime, continued with my investigation. I had to establish for a fact whether Mr. Bodhi had actually gone to India or not. So I had gone to some of my contacts that I knew in the police, and asked them, because I don't have the capacity as a private person to find out from Home Affairs whether they, to investigate the travel. So it was the normal things. We had to establish for a fact, had he been to India, because it was just information. He could not have been there. And as it is, I established that he hadn't been there in 2014, that he'd actually been there in 2015, in August.
How long were you in Dubai?
Sorry?
How long were you in Dubai?
It was a 2-day conference. So I fly in, we have a conference, and the next day or so we fly back.
So you came back on the 12th?
On the 12th of the morning, yes.
Yes. And then you get a call on the 14th from Mr. Breski.
Yes. From Mr. Breski, yes.
Yes. Mr. Breski telling you that Mr. Van Jaarsveld has now told him that he has been approached. So now we've got information that we heard about in Dubai. Now you've got information that Mr. Van Jaarsveld has been approached.
And Mr. Alexander.
Mr. Chairman, sorry to interrupt again,
Yeah.
but we're now going into a cross-examination which Mr. July shouldn't be doing, because this is not meant to be a cross-examination of the witness. It's meant to clarify issues that his evidence raised, but which is relevant to the terms of reference. We're now going into the nitty-gritty of the match-fixing investigation. And you knew Mr. Bodie because you had the information note from the ICC. What did you do with that information? That, with all due respect, has nothing to do with the terms of reference. In all fairness, we curtailed Mr. Cole's evidence yesterday on the basis that this is not about match fixing, but only whether there was discrimination, and unfair discrimination.
But both in the, if you remember yesterday, I remarked that both in the in the affidavit as well as in the testimony, I kept on asking to what extent does all of this evidence, because I am very wary about us having to deal with match fixing, because I don't think that is what we are here about. Match fixing must be match fixing relevant only to the extent that it will show what is sought to be addressing the terms of reference. Was there any racial discrimination of an unfair nature in the manner in which this match fixing was conducted? And was there any gender discrimination? Those are the main areas of my investigation or of my inquiry. Now, I allowed a lot of latitude. And if you read your affidavit, Mr. Cole's affidavit, a lot of it is devoted to how match fixing, was done. Even the clip that was played yesterday, I was quite concerned where it was going to go to. But I allowed that at latitude because I kept on being assured that it is in the end going to be addressing the terms of reference. So I think I must allow an equal latitude for me to understand whether at the end the cross-examination is seeking to bear out what eventually.
I think with all due respect, Chair, you're misunderstanding the objection that I'm making.
Yes.
Mr. July's role is not to cross-examine a witness during these proceedings. These proceedings are not a court process where Musaji is presenting the evidence in chief and Mr. July is then cross-examining the witness. Mr. July's role is to gather the information, just as I try to assist in gathering the information. But we're now having Mr. July cross-examining Mr. Cole. And I don't think it's fair and appropriate to say that you allowed latitude. Let me just take these hearings through the note that was received from this particular hearings. they say, we believe that the responses to the aforesaid issues will assist the investigative work of the Office of the Ombudsman. We wish to stress that this notice should in no way limit you in responding to allegations contained in affidavits and transcripts regarding the match-fixing investigation. So we know that in the affidavits that were filed, there were various allegations made against Mr. Cole and Mr. Becker. In order to address those investigations, we had to take you through the process of the investigation, because without knowing the background to who had been investigated and why people were going to be charged, there's no way Mr. Cole can establish that he didn't treat people unfairly and he didn't treat or target black players as the suggestions were made when the players gave evidence. But that does not mean that we didn't curtail the evidence. After Mr. July and I had that exchange, you urged me and you told me you've seen what's in the affidavit and I must try to limit it. And I did then try to rush through a lot of it. And I said, for example, on the mirror imaging of the cell phones, where there's critical information. Sorry, Mr. Chair, are you okay? Is that the knee?
Yeah. Okay.
So where I deliberately curtailed the evidence. Otherwise I would have continued in the greater detail that I did. Having curtailed that evidence, we're now facing a scenario where Mr. July is cross-examining the witness. And I don't think that's fair in this process.
Mr. July?
Can I come? Chair, first and foremost, the evidence, whether it was rehashed here orally, is before you. The affidavit is before you. And if I come across as a person who's cross-examining you, Mr. Cole, yes, then I apologize, because I have no intentions to cross-examine you.
Do I have to answer those questions, sir?
Yes, because even clarity questions, a question is a question, has to be answered, even if it's clarity. But if I come across as a person who's cross-examining, that is not my intention. I just want clarity. So if you are saying to me, no, it's contained in my affidavit somewhere, or I would have said this if I was given an opportunity, there's still no harm if I ask you by way of clarity.
Mr. Ombudsman, I did say that the investigation was 18 months. I was alone. I go into my affidavit into detail, not as much detail as in my police affidavit. If I'm expected to give a day-to-day account of how I progressed the investigation, I flew down to Cape Town to see Mr. Breedske to get the information from him. I had to interrupt my involvement in the tournament that was at hand to do that. So I was doing many things at the same time. I had to interact with the ICC with regard to every bit of information that I got. So I know that Mr. Peterson alluded to the fact that I did nothing, and Mr. Totobi says that I did nothing for 3 months. One just has to glance at my affidavit to see that there was quite a lot of investigation that into that. I did not sit back and not give attention to the investigation as it unfolded. There was a lot that went on during that.
Yeah, Mr. July, I think you also said that you only want to ask questions that are in clarification of his evidence, contained in the 336 paragraphs of his affidavit officer. I think you should curtail what might come across as cross-examination, yes, to just clarification questions.
Okay. Maybe I should change how I ask this question, because it has never been my intention to cross-examine you. Now, let's go back when you started in January 2015.
Correct, sir.
You attend Keep Cricket Clean
The purpose of the meeting was not to keep clean. It's an annual conference, so where we deal with what happens in the domestic board of Cricket South Africa, Cricket Australia, Sri Lanka. So each of us give the theme of the ICC cricket is keep cricket clean, but that was not the purpose of the meeting.
Yeah. As I understand, I'll tell you why it was the purpose largely about keep cricket clean, because there were complaints about how the corruption unit, in particular, of the ICC was leaking information and all of that. And that resulted...
That particular conference?
No. In that conference, you were not discussing that. Yes. What you were discussing in that conference were the recommendations made by the IWP, one of the issues that you did.
Those were some of the issues, but it was not the purpose of all of it.
Okay. Let's take it one at a time. Whatever the conference was about, but at that conference, you also discussed the issue about each region, more especially the full member of the ICC, having its own corruption unit.
Yes, we did discuss that. Yes, we did discuss that. But it was a long run-up of the Integrity Working Party that they had their own investigations. Just prior to my going to Dubai, I had a teleconference with Mr. Logat and with Mr. Dave Richardson about these recommendations. And so some of the feedback, some of the discussions were about that, but it was not essentially that, but it was part of the discussion.
Yes, I would accept that it was part of that. You know, in 2014, I know that you were not part of Cricket South Africa, but in 2014, the Integrity Working Party was mandated to do the review of the processes, functions, and resources of the anti-corruption unit of the ICC.
That is great.
Yes. And then in 2015, in June, in the conference that was held in Barbados, 22 June to 26 June.
2014?
No, 2015 at Barbados. Those recommendations that were made by the IWP were then adopted by the ICC board.
Yes.
Yes. So you've got a 2014 investigation, you've got a 2015 where the recommendation are adopted in June, right? In September, one of the issues that are being discussed are the recommendations.
Some of them, yes.
Yes. Now, I want you then to tell me at what point did you have the anti-corruption code for South Africa, Cricket South Africa?
On the first, when was it adopted by Cricket South Africa?
Yes.
In September?
Yes.
Yes.
When in September?
Could be the first.
The date is, the effective date is the first.
Yes.
I'm talking about the adoption. When was it adopted by the board?
I would not know.
Okay. Maybe we would need to have that resolution by the board.
Yes. With all due respect, he's not a board member. He can't produce that resolution. That should be put to CSA if needs be. But Mr. Cole is not a board member. He can't put forward a resolution. Again, I don't understand why we're putting CSA through the trouble of producing resolutions when that has nothing to do with the question of people were racially discriminated or not. If you want to suggest that people could not have been charged because the effective date was afterwards, then you can suggest that. But that has nothing to do with the question of whether people were discriminated against on racial grounds. In any event, we had evidence from this particular witness yesterday that said even before CSA formally adopted the resolutions, you had training and education on anti-corruption. We also know as a fact, by virtue of the evidence given by this witness yesterday, that Hansie Cronje, Henry Williams, and Herschel Gibbs were charged with corruption-related offences even before there was a formal code in place. And that was even before there was an ICC code in place.
So what is the objection, Mr.?
My objection is this has nothing to do with discrimination on racial grounds. Why are we going down this line?
Mr. July?
The charge sheet, Mr. Cole, that you gave to all the players who were charged make reference to the code. And in your paragraph 5 of your affidavit, you make reference to both the international ICC code and the CSA anti-corruption code, right? And I will tell you why I don't agree with your version. You'll tell me if I'm wrong about the ICC code. You took the 2014 ICC code, which was applicable at the time, and you converted that and you domesticated that.
Correct.
Right. And all what you did was to change the international to domestic.
Correct.
And that's where the importance comes in, because there is no way that you could have charged these employees in terms of the ICC code, for simply reason that the REMSLAM was not an international.
Mr. Chairperson, again, I raised the objection. The question being put to the witness has nothing to do with whether the players were discriminated against on the basis of race. This witness was curtailed yesterday on the basis that we should stick to evidence relating to the terms of reference. And we allow...
At what stage was that? I mean, because... At what stage did I curtail
that was after Mr. July said the video was useless. I don't know how somebody could make that statement without understanding the evidence that was going to come. And we said we were going to, when we go through the chronology, we will go back to that particular phase. I'm afraid, and I'm putting it on record, Mr. Chairperson, if you dismiss my objection, you can dismiss my objection. But I'm placing it on record that questions are being put to this witness as if the witness is being cross-examined and outside the terms of reference. That's my objection, Mr. Chairman.
Mr. Chair, can I just remind Mr. Musaji? Yesterday we counted up to 15 and we stuck on 15, setting out what are the evidence that proved that the investigation was not based on, and players were not targeted on the basis of race. So there's evidence that was accepted here. All what I'm dealing with also, when they started, Mr. Chair, you will recall, they started with paragraph 5. That's exactly where the examination in chief began, with paragraph 5. And all what I'm doing now is asking Mr. Cole about the international code, its applicability to a domestic match, and whether the CSA code was in place at the time when the investigation or when the allegations against Bode were made.
Mr. Chair, can I...
Mr. Musaji's objection seems to be that has nothing to do with the terms of reference.
Mr. Symes was also charged under that code in his right. And Mr. Chairman...
Just wait, let the Chairman...
I apologize.
Mr. Chairman, can I just reply before you make a ruling, Mr. Chairman?
Yes.
Mr. Chairman, it doesn't help to say that they started with the code yesterday. Yes, we did start with the code, and we said that that was just to demonstrate to you a background, that there was a code, and you had an international code, and you had a CSA code. But we didn't turn around and say we had to charge the players because the code said we had to charge the players. Mr. July refers to 15 instances of information. That 15 instances of information had nothing to do with the code. And I can take you through the 15 if you want me to. It was, number one, Vaughan van Jaarsveld gave information that implicated Mr. Bode. Then you had Craig Alexandra that gave information that implicated Mr. Bodie. Then you had Alviro Peterson that gave information, and he implicated not only Mr. Bodie, or in fact, he doesn't implicate Mr. Bodie, he implicates Mr. Tsolakile and Mr. Tsotsobi. Then you get a statement signed by Mr. Peterson, where again, various people are implicated. Thereafter, you had Bodie giving information and implicating a whole lot of people. Then you had information from the cell phones. Now that's number 6. Number 7, after the information from the cell phones were provided, there were meetings with Mr. Tsotsobi, number 7, Mr. Tsolakile, number 8, Mr. Symes, number 9, Mr. Machikwa, number 10, Mr. Mbalati, number 11, where there were sources of information. We know that the evidence from this witness was that all of them did not make full frank disclosure at the very beginning. All of them were convinced by Mr. Bodie at the very beginning to simply say that they had been approached and they rejected the approach. But through the cell phone records and other information, Mr. Cole and Mr. Becker were able to identify that there wasn't full and frank disclosure, and then they started interviewing those people again. Eventually, Mr. Bodie comes clean, and Mr. Bodie even goes as far as not only saying they were approached and they turned me down. In fact, he says they were approached and they participated. Some of them even received money. Now let's accept this debate about which code or the code wasn't in place. The mere fact that they accepted money is a corrupt relationship already in order to fix a particular portion of the game. So that was the 13th. Then we know we got Mr. Symes and Mr. Machikwa that delivered other affidavits. Then we had Mr. Mbalati deliver other affidavits. That's now the 15th source of information. So this has nothing to do with which code was applicable. And I'm very, very concerned, Mr. Chair, that we're not now limiting the evidence to what falls within the terms of reference as you urged us to do yesterday.
Yeah, Mr. July, I think you must just cut to the chase. You may highlight the areas which you are going to be arguing in the end, because I think all now he has a viewpoint. You also have a viewpoint. You should make sure that when it comes to presenting your argument, you will have covered all the evidence in a way in which it will not be suggested that there was a witness and you didn't put it to the witness.
Yeah. Chair, I can put that it is a matter of fact, Mr. Cole, that you charged the witness,
I didn't charge them.
that whoever charged them, the players were charged in terms of the CSA code which came into effect on the 1st of September. Right?
Yes, correct.
So can I ask for 5 minutes
Yes.
break? Then I will decide whether do I continue with this
Okay.
or not.
All right. It's now 11:15. 20 past 11. We'll resume at 20 past 11. We are adjourned for 5 minutes.
Thank you.
We resume. I need to remind you, Mr. Cole, that you are still under oath.
Yes, I am, sir.
Yes. Mr. July?
Mr. Cole, in paragraph 11 of your affidavit.
Of mine?
Yeah.
Yes, sir.
Yeah, you state in that paragraph that you undertook training
Yes, sir.
for the players in November. Is it October, November?
Yes, sir. Period.
Period. In respect of the code.
Yes. The obligations in the code, yes.
Yes. You also you said if Peterson told you about the meeting that took place, that happened on the...
What meeting is that, sir?
On the 10th?
The one in Dubai?
No. Was it in Dubai, the 10th of October, with Peterson, with Bodie?
No, it was in the car park at the Wanderers.
Yes. You would have had an opportunity to go and arrest Bodie. Did I get you right?
No, you got me totally wrong, sir.
Which meeting did he not disclose?
The 29th of October, where you met Mr. Manis Jain, and the 4th of November, when you met with Vicky Savant and the others.
According to Mr. Peterson and also your affidavit, on the 3rd of November, he WhatsApped to you.
Yes, that's correct.
That Mr. Bodie is in Durban.
That's correct, yes.
So you knew that Mr. Bodie was in Durban?
He said to me that he was. I was looking for him. In fact, I sent Mr. Ari de Beer, who was my counterpart at the ICC, who was assisting me. I sent him to Mr. Bodie's house to go and look for him, because I couldn't find him yet.
Yes. Mr. Chair, those are the questions. Yes.
Mr. Cole, apologies. During the course of the SJN hearings, we heard a lot of complaints and responses regarding the appointment processes of CSA. And in light of that, I'm interested to know how you were appointed as the anti-corruption officer for CSA.
There was an advert. As I say, I was happily retired at the time, and maybe I should have stayed retired. But there was an advert to which I responded. I was then called into a interview process with a lot of other people, and I heard later that I'd been appointed.
Thank you very much.
That is the evidence. Thank you, Mr. Cole.
Thank you, sir.
We will adjourn until 12:30. Is Mr. Becker on the line? But these proceedings are adjourned, and we will resume with Mr. Becker later on.